Should a person who is currently under a domestic violence injunction or a restraining order be able to possess a firearm? Well, a federal court of appeals recently said yes, so let's talk about that decision. Once again, this 2A victory is out of Texas and was ultimately decided by a 3-judge panel of the United States Court of Appeals for the 5th Circuit. Now, if you've been following the Firearm Firm channel, you will know that most of the recent favorable 2A decisions have been coming from Texas and from the 5th Circuit Court of Appeals, which is the very same court that found the bump stock ban to be unlawful in Cargill versus Garland. So in my mind, there is no question that the great state of Texas and the 5th Circuit Court of Appeals understand the true meaning of shall not be infringed. Here's what led up to this recent ruling. Back in 2021, Zachary Rahimi was indicted by a federal grand jury for being in possession of a firearm while under a domestic violence restraining order in violation of 18 U.S.C. 922G8. Now, leading up to this indictment on this charge, Mr. Rahimi had been involved in multiple shootings around Arlington, Texas that resulted in the Arlington Police Department seeking and obtaining a warrant to search Mr. Rahimi's home. While they executed the search warrant, the police located a rifle and pistol inside Mr. Rahimi's home, which Mr. Rahimi admitted was his. He further admitted to law enforcement that he was subject to an agreed-upon civil protective order that was issued by a Texas court for the alleged assault on his ex-girlfriend. After being indicted by the grand jury, Mr. Rahimi filed a motion to dismiss the indictment based on 18 U.S.C. being unconstitutional because it violated Second Amendment rights. It was denied by the district court because of prior precedent and Mr. Rahimi appealed this decision to the 5th Circuit Court of Appeals, which also denied the motion to dismiss based on prior precedent. However, after the United States Court issued their ruling in New York State Rifle and Pistol Association versus Bruen, the 5th Circuit Court of Appeals withdrew its prior opinion on Mr. Rahimi's case and set it back on the docket for hearing. The reason why the 5th Circuit Court of Appeals did this is because when the case was first appealed, the 5th applied a two-step analysis standard in deciding whether or not 922G impacted the Second Amendment. Subsequently, the Bruen decision came out and the United States Supreme Court held that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. In that context, the government bears the burden of justifying its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. Put another way, the government must affirmatively prove that its firearm regulation is part of the historical tradition that delimits the outer bounds of the right to bear arms. The government first argued that the Second Amendment only applies to law-abiding, responsible citizens and ordinary law-abiding citizens, which had been phrases the United States Supreme Court had used in the Heller and Bruen decisions prior to this ruling. And since Mr. Rahimi is neither responsible nor law-abiding, he falls outside the ambit of the Second Amendment. The 5th ultimately determined that the United States Supreme Court's reference to law-abiding responsible citizen in the Heller case meant to exclude from the court's discussion the groups that have historically been stripped of their Second Amendment rights, i.e. groups whose disarmament the founders presumptively tolerated or would have tolerated. And because Mr. Rahimi did not fall into such group at the time he was charged with violating 18 U.S.C. 922G8, the 5th ruled that there was a strong presumption that he remained among the people protected by the Second Amendment. After losing this argument, the government was left to point to historical precedent from before, during, and even after the founding that evinces a comparable tradition of regulation. Now, I do think the government did a good job trying to show this by looking at other similar historical regulations, but ultimately the court was unpersuaded and found that the restrictions of 18 U.S.C. 922G8 did violate the Second Amendment and therefore was unconstitutional. I will attach a copy of the order for anyone wanting to read the entire order down in the description section to this video. Also, be sure to let us know what you think about this ruling down in the comments section below, along with any questions you may have about this video or any other Second Amendment related questions. Finally, if you made it this far in this video, then you obviously found the content to be informative, so you might as well go ahead and subscribe to the Firearm Firm channel if you haven't already done so by clicking on the subscribe icon in the lower right hand corner of this video. Also, don't forget to hit the like button and turn on the notification so you can be notified when we release our weekly videos. Until next time, stay armed and educated.